My name is Lieutenant Strom, and I'll be reading you the slide deck from Army EEO, Anti-Harassment and No Fear Training. The course contains mandatory training on equal opportunity, equal employment opportunity, Army anti-harassment policy, no fear, prohibited personnel practices including whistleblowing protection laws. The Army is committed to ensuring equal opportunity in employment for Army civilian employees and applicants. The Army is committed to developing and maintaining a professional workplace in which all individuals are treated with dignity and respect. It includes ensuring an environment for Army civilian employees free of discrimination in employment on the basis of race, color, religion, sex, national origin, age, disability, genetic information, reprisal or retaliation for opposing discrimination, or participating in discrimination against complaint activities such as being a witness for another employee. As a supervisor or a soldier, you must have legitimate, non-discriminatory reasons for every personnel action you take. Federal anti-discrimination laws protect employees from illegal discrimination in the terms, conditions, and benefit of their employment. Some examples of these are hiring, promotion, reassignments, pay, leave, awards, performance evaluations, training, job classifications, reprimands, suspensions, terminations. Race discrimination involves treating someone, an applicant or employee, unfavorably because the person of a certain race or personal characteristics associated with a race, such as hair texture, skin color, or certain facial features. Color discrimination involves treating someone, an applicant or employee, unfavorably because the person has a certain color of skin. National origin discrimination involves treating someone, an applicant or employee, unfavorable because the person is in a particular country or part of the world, or appears to be a certain ethnic background, or has an accent. Religious discrimination involves treating someone or applicant or unfavorable because of the person's religious beliefs. An employee cannot be forced to participate or not to participate in a religious activity, such as a condition or employment. The law requires reasonable accommodation of an employee's religious beliefs, practices, unless doing so would cause more than a minimal burden on the Army's operations. Reasonable adjustments to the work environment may allow an employee to practice their religion without disrupting Army operations. Sex discrimination involves treating someone, an applicant or employee, unfavorably because of that person's sex. It includes treating a person, an employment applicant or employee, unfavorably because of sexual orientation, gender, identity, pregnancy, childbirth, or medical condition related to the pregnancy or childbirth. Age discrimination involves treating someone, an applicant or employee, less favorably because of age. The Age Discrimination in Employment Act forbids age discrimination against people who are 40 or older. It does not cover workers under the age of 40. Disability discrimination occurs when a qualified applicant or employee with a disability is treated unfavorably because the person has a disability. Disability discrimination also occurs when a qualified applicant or employee is treated less favorably because the person has a record of a disability, such as a cancer that is controlled or in a remission, or because the person is regarded as having a physical or mental impairment, even if the person does not have such an impairment. Discrimination can also involve treating people unfavorably because they associate with others or of a different group, such as association with someone of a different race or a person with a disability. The use of genetic information as making employment decisions is prohibited. Genetic information includes information about an individual's genetic test and the genetic test of an individual's family members, as well as information about the manifestation of a disease or disorder in an individual's family members, i.e. family medical history. Family medical history is included in the definition of genetic information because it is often used to determine whether someone has an increased risk of getting disease or disorder or condition in the future. A supervisor may not request genetic information such as family medical history from employees. Supervisors might inadequately acquire genetic information because an employee volunteers it or through overhearing others talk about it. This is not unlawful because the supervisor is not seeking out the information. To the extent possible, however, supervisors should seek to avoid participating in conversations where genetic information might be revealed. Michael's supervisor, Amanda, who works for him, comes into his office and indicates her relative died from disease that she might have been diagnosed with the same disease and needs to take leave. Michael tells Amanda he is sorry to hear this. He says he will work with her and an office manager to assist with leave options. Michael tells Amanda to let him know if she needs any other assistance with the job during the treatment. Michael acted appropriately by keeping his remarks about the medical conditions brief and keeping the conversation focused on work issues. Although it is difficult to do, supervisors should avoid engaging in a conversation about the specifics of the medical condition or the relative's medical condition. It is illegal to retaliate against applicants or employees because they filed a charge of discrimination because they complained about discrimination on the job or because they participated in an employment discrimination proceeding, such as an investigation or a lawsuit. If an employee you supervise has contracted the EEO office or participated in EEO activity, continue to work with the employee as normal, fully cooperate with the EEO counselor or investigator, contact your activity servicing labor for guidance, afford the employee a reasonable amount of duty time to participate in the EEO activity, consider mediation to resolve EEO complaints. Employees seeking resolution of alleged unlawful discrimination, harassment, or retaliation must contact the EEO within 45 days. That's a big number, 45 days of becoming aware of the alleged discrimination. EEO counselor will attempt to resolve, may offer opportunity to use the alternate dispute resolution process. If unable to resolve the issue, will provide a notice of file to complete an EEO complaint. Employees covered by a negotiated bargaining agreement with permits allegations of discrimination have an additional option. Either elect to proceed under the negotiated bargaining agreement or file a formal complaint of discrimination with the EEO office. Cannot do both. If an employee you supervise has contacted the EEO office with a complaint or participated in EEO activity, do not confront the employee, do not discuss with the employee, do not try to avoid the employee. Act as normal. Federal laws enforced by the EEOC that protect employees from employment discrimination are Equal Pay Act 1963, Title VII of the Civil Rights Act of 1964, AIDS Discrimination Employment Act of 1967, Rehabilitation Act of 1973, Pregnancy Discrimination Act of 1978, Genetic Information Non-Discrimination Act of 2008. A reasonable combination is a change in a workplace or that things that are customarily done that helps an individual with a disability to do their job. Reasonable accommodations can involve most things that enable an individual to perform a job, or have equal access to the workplace and employee benefits. As a supervisor, you are responsible for providing reasonable accommodation to an employee or job applicant with a disability unless doing so would cause significant difficulty or expense for the Army, undue hardship. An employee who believes that they need a reasonable accommodation for a disability may make an oral or written request to you. The request does not have to be used in terms of reasonable accommodation. Supervisors must respond in a timely manner, 30 days or less, to requests for reasonable accommodation. Examples of reasonable accommodation include providing documents and forms in alternate formats like large print or braille, sign language interpreters, flexible work schedules, telework, parking spaces, as well as removing physical barriers in an office or cafeteria. An employee must let the supervisor know for the need for an adjustment or change concerning some aspect of the job or benefit of employment for a reason related to a medical condition. An employee needing a reasonable accommodation or a recurring basis, such as the assistance of a sign language interpreter, must be given appropriate advance notice each time the accommodation is needed. Generally, job applicant must let the selecting supervisor or HR who are managing the job application process know of the need for an adjustment or change concerning some aspect of the application process. An applicant may request a reasonable accommodation at any time, orally or in a writing. A request does not have to include any special words such as reasonable accommodation, disability rehabilitation. A request is any communication in which an individual asks or needs a change because of the medical condition. If the nature of the initial communication is unclear, the supervisor or decision maker should ask the requester for a clarification of the needed for a reasonable accommodation. If the requester's disability and or need for accommodation are not obvious or already known, the supervisor is entitled to ask for and receive medical information showing that the requester has a disability that requires accommodation. A disability is obvious or, when known, is clearly visible, or the individual previously provided the medical information showing that the condition met the Rehabilitation Act. Information about reasonable accommodations include medical information must be maintained in a secure location. It may not be filed with the other personnel information pertaining to the employee. Even if medical information is needed to process a request, the supervisor does not necessarily have to request medical documentation from a medical health care provider. In many instances, the requester may be able to provide sufficient information that can substantiate the existence of a disability and or need for the reasonable accommodation. If an individual has already submitted medical documentation in connection with a previous request for accommodation, the individual should immediately let the supervisor know. If medical documentation is provided, it should be evaluated or validated by the organization's occupational health advisor or government medical advisor, who can advise the supervisor on the scope of the accommodation requested. Under the Rehabilitation Act, medical information obtained in connection with a reasonable accommodation process must be kept confidential. This means that all medical information that the supervisor obtains in connection with a request for reasonable accommodation must be kept in a secured file separate from an individual's personnel file. This includes the fact that an accommodation has been requested or approved, and information about functional limitations. It also means that any employee, supervisor, or management official who receives such an information is strictly bound by these confidential requirements. Should questions arise from coworkers about what is perceived as different or special treatment of an accommodating employee, the supervisor should explain the policy of assisting any employee who encounters difficulty in the workplace, and that may have any workplace issues encountered by employees or personnel, and is the Army's policy to respect employee privacy. The decision maker may be able to not grant that request for reasonable accommodation immediately. If not, interactive process should be used with the employee to exchange information and search for solutions. At the end of this process, the employee should know whether the request has been granted or denied. The decision maker does not have to provide specific accommodation requested if there are reasonable and effective alternates available. During that discussion, alternates may be offered. The decision to grant accommodation must be promptly communicated orally or writing to the requester. A decision to provide an effective and reasonable accommodation other than one requested is still a decision to grant an accommodation. A decision to deny a request for accommodation must be provided to the requester promptly in writing. The written denial must state the specific reasons why they request the accommodation would not result in undue hardships or be ineffective. A decision maker who denies the request must consult with a disability program manager and staff judge advocate before denying any requested accommodations. You may immediately grant the request or engage in an interactive process with the employee to exchange information and develop effective solutions. The accommodation must be reasonable and limited to essential job functions. Changing supervisors and lowering performance standards are not reasonable accommodations. If the initial information provided by the health professional or the requester is insufficient to enable the supervisor to determine whether the individual has a disability and/or an accommodation is needed, the supervisor, in consultation with the organizational occupational health advisor, will explain what additional information is needed. If necessary, the requester should ask one of their health care provider or the appropriate professional to provide the missing information. First aid, medical responders, and safety personnel may be informed when appropriate. The disability might require emergency treatment or assistance in evaluation. HR and EEO officials may be given information necessary to investigate the agency's compliance with the Rehabilitation Act or report the other information as required. Here, common types of accommodations include granting breaks or providing leave, moving to a different office space, making changes in workplace policies, or providing accessible parking. Army anti-harassment policy for the workplace. Workplace harassment is based on race, religion, color, sex, national origin, age, disability, genetic information, reprisal, or any other impermissible basis is not acceptable in either the military or civilian ranks. Harassment includes, but is not limited to, any offensive content such as slurs, jokes, or other verbal, nonverbal, or physical contact or physical conduct that has the purpose of or effect of unreasonably interfering with an individual's work and performance or creating an intimidating, offensive, or hostile environment, even if a single utterance, joke, or act does not rise to the level of the actionable harassment under the law. Such as conduct is contrary to the Army values. Sexual harassment is a form of sex discrimination. Sexual harassment includes unwelcome sexual advances, requirements for sexual favors, and other verbal or physical conduct of a sexual nature when submission of it to a conduct is made either explicitly or implicitly in a term or condition such as a person's job, pay, or career, or submission to a rejection of such conduct by a person is used as a basis for a career. Submission to a rejection of a conduct by a person is used as a basis for career employment decisions affecting the person, or such conduct has the purpose of or effect of unreasonably interfering with an individual's work performance or creates an intimidating, hostile, or offensive working environment. Who can commit workplace harassment? The harasser can be a coworker, the employee's supervisor, a supervisor in another area, or someone who is an employee of the Army, such as a client, contractor, or customer. Both the employee and the harasser can be either a woman or a man, and the employee and the harasser can be the same sex. Examples include, but are not limited to, verbal conduct that could include racial or sexual epithets, foul language, unwanted sexual flirtations, ethnic jokes, derogatory statements, or slurs. Physical contact that includes improper touching or sexual assault, or visual harassment that can include racially or sexually explicit or derogatory posters, cartoons, drawings, obscene gestures, or items such as a noose. EEO, effects of harassment, discipline or loss of job and engage in harassment, lower productivity and morale, emotional and physical pain, higher turnover, higher cost for hiring, potential liability for damages and attorney fees, embarrassment to the Army, degrades mission readiness. If you are subject to harassment, promptly report your concerns to the chain of command, the IG or Inspector General, or a supervisor to whom you feel comfortable reporting to, so that your command can can investigate and take steps to end harassment. If desired, contact your supervising EEO office to file a complaint within 45 days. Again, 45 days after you first become aware of the harassment or reasonably should have known. If you as a supervisor receive a complaint or harassment, it is your responsibility to take prompt and appropriate action. It is the Army policy to treat all employees with dignity and respect, and that no one should be harassed, bullied for any reason. No, not all harassment is EEO related. You may need to take steps to protect the person complaining from further harassment. If allegations of harassment are raised, you must immediately consult with your servicing staff, judge, advocate, who can advise you on the appropriate counsel or course of action. If harassment occurred, it is your responsibility to take corrective action designed to end harassment. Discipline, which would include termination, may be warranted depending on your conduct. You must take progressively severe action if the harassment does not stop. Sex discrimination. Sex discrimination involves treating someone, an applicant or employee, unfavorably because of their person's sex, and includes treating a person or applicant or employee unfavorably because of a pregnancy, childbirth, or medical condition related to a pregnancy or childbirth. Treating someone, an applicant or employee, unfavorably because of that person's sexual identity or sexual orientation. Executive Order 13087 explicitly prohibits discrimination based on sexual orientation. Allegations of discrimination based on a sexual orientation may be addressed through the EEO process or a complaint to the Office of Special Counsel. Discrimination based on sexual orientation may constitute a prohibited personnel action appealable to the Merit Systems Protection Board. When dealing with workplace issues involving interaction with the employee, treat individuals with dignity and respect. Make it clear that your workspace is a safe space. Speak up if you hear a discriminating comment, name, joke. Do not make assumptions about employees' background or preferences. Be inclusive in everything you say. Use proper name and pronoun appropriate to the employee when communicating with or about the employee. Should questions arise from coworkers about what is perceived as different or special treatment of an employee, you should explain the policy of assisting any employee who encounters difficulty in the workplace and that the information is personal. It is the Army's policy to respect employees' privacy. Army personnel who condone or commit acts of workplace harassment may be subject to the following disciplinary actions: oral, written, admonishment, counseling, reprimands, suspension from duty for pay status, involuntary reduction in grade, removal, involuntary separation, or criminal prosecution. Harassment, online misconduct. Electronic communication is the transfer of information, signs, text, images, sound, or data transmitted by computer, phone, or other electronic devices. Not limited to text messages, emails, chats, instant messenger, screensavers, blogs, social media sites, electronic device applications, and web video conferencing. Responsible online conduct means that when using electronic communication, members of the Army team should apply think, type, post. Think about what messages, information is being communicated, who could potentially view it. Type any messages or convey information that is consistent with the Army values. Post if the messages, information is responsible and demonstrates dignity and respect for others. Online conduct is the use of electronic communication as an official personnel capacity that is consistent with the Army values and standards of conduct. Online misconduct is the use of electronic communication to inflict harm. Examples include, but are not limited to, harassment, bullying, hazing, stalking, discrimination, retaliation, or any other types of misconduct that undermines dignity and respect. Prohibited personnel practices. Civil Reform Act of 1978 promotes overall fairness in federal personnel actions. A federal employee who is authorized to direct others to take, recommend, or approve any personnel action may not discriminate against an employee applicant based on color, religion, sex, national origin, age, mental or physical disability, marital status, or political affiliation. Ask for or consider employment recommendations based on factors other than the personal knowledge or records of job-related abilities or characteristics. Coerce the political activity of a person or take the action in reprisal for refusing to engage in political activity. 19th Act continued. Decisive or willful obstruction anyone from completing for employment, influence anyone to withdraw from competing for a job to help or hurt the employment prospects of another person, give an authorized preference or advantage to anyone that improves or hurts the employment prospects of an employer or applicant, hire, promote, or advocate the hiring of or promotion of relatives, nepotism, engage in reprisal or retaliation for whistleblowing. Continued. Fail to take, or threaten to take a personnel action against an employee or applicant for filing an appeal, complaint, or grievance, testifying for assistance another in an appeal, complaint, or grievance, cooperating with or providing information to the special counsel or to an inspector general, or refusing to obey an order that would require the individual to violate a law. Discriminated based on employee's personal conduct which is not adverse to the on-job performance of an employee, applicant, or others. Knowingly take or fail to take, recommend, or approve a personnel action that would violate a veteran's preference requirement. Take or fail to take a personnel action that would violate any law, rule, or require regulation implementing or directly concerning merit systems principles. The Office of Special Counsel, OSC, is an independent federal agency that investigates complaints or prohibited personnel practices other than those enforced by EEOC under the Civil Service Act Reform Act of 1978, including discrimination on the basis of marital status, political affiliation or activities, sexual orientation, conduct that does not adversely affect employee performance, whistleblowing retaliation. Whistleblowing procedures. A federal employee authorized to direct others to take, recommend, or approve any personnel action which may not retaliate against an employee for protected whistleblowing. Whistleblowing is when an employee or applicant discloses information that he or she reasonably believes is evident of a violation of law, rule, or regulation, gross mismanagement, gross waste of funds, abuse of authority, or a substantial and specific danger to public health or safety. Disclosures may be made to supervisors in the chain of command, supervision, inspector generals, Congress, law enforcement officials, agency ethnic officials, or any other agency officials responsible for ensuring integrity and acting against maleficence within the agency. The Office of Special Counsel also provides a secure channel through which employees may make confidential disclosures, whistleblowing. OSC evaluates the disclosures to determine whether there is a substantial likelihood that one of the categories listed above has been disclosed. If such a determination is made, the OSC has the authority to require the head of the agency to investigate the matter. Sometimes it may be against the law or executive order to disclose certain information, especially when it is in the interest of national defense or the conduct of foreign affairs to keep the information secret. If disclosure of the information is restricted by law or executive order, it is only protected to the information is given to the special counsel, the inspector general, or comparable agency official. If you believe you have been subject to whistleblowing retaliation or other prohibited personnel practices, you may access the forms from the OSC website and either file your complaint to the OSC online or print the forms submit by mail. OSC requires the use of specific forms to file a complaint not submitted via online form. These forms are available on the OSC website. For more information, contact http://www.osc.gov. Merit Systems Protection Board. The Merit System Protection Board is an independent federal agency established to protect federal merit systems against partisan, political, and other prohibited personnel practices and to protect federal employees against abuses by management. The MSPB has the authority, in part, to review and issue rulings on the appeals of personnel actions, such as removal, suspensions of that 14 days, furloughs, and demotions. Appeals of administrative decisions affecting right or benefits under the Civil Service Retirement System or the Federal Employees Retirement System. Complaints filed under the Whistleblowing Protection Act, the Uniform Service Employment and Redeployment Rights Act, and the Veterans Employment Opportunity Act, and cases brought by OSC. If you believe that a personnel action has been taken on the basis of your race, color, national origin, sex, age, disability, or retaliation for opposing such discrimination or participating in the discrimination complaint process, and that personnel action is appealable to the MSPB, you may choose to file a complaint with EEO or file an appeal with MSPB, but not both. The appeal must be filed with the MSP within 30 days of the effective date of the personnel action. Information regarding procedures for filing MSPB appeals can be found on the MSPB website, http://www.mspb.gov. Negotiated grievance procedures. Employees under a bargaining unit agreement may be able to file a complaint or discrimination through a union negotiated grievance procedure. The No Fear Act requires each federal agency to pay for awards, judgments, and settlements involving discrimination and whistleblowing from its own budget. This means your activity will be responsible for paying out of its own budget for adverse awards, judgments, and settlements in federal lawsuits and the administrative complaint process. Congratulations, you've completed.